Good morning, everyone. Thank you so much for joining us. We will be starting in 1 minute. Thank you for your patience. Good morning and welcome. We'll be starting in 1 minute. Good morning and welcome to today's webinar. My name is John Torres. I'm the Vice President for Public Relations at the National Cooperative Business Association. And thank you for joining us today for the webinar of Navigating SBA's Paycheck Protection Program. This webinar is produced by the National Cooperative Business Association in partnership with the National Cooperative Bank and law firm Dorsey. For more information and resources on the COVID-19 response, please visit our microsite at ncbaclusa.coop/COVID-19-resources. Today's webinar is scheduled for 1 hour and will unpack the details of the PPP program and provide an update on other advocacy efforts related to the COVID-19 response. Before we begin, I will just like to mention a few housekeeping items. Participant phone lines will be muted during this presentation to reduce some background noise. There will be a chance to pose a question, just not verbally. If you have a question, please type it into the question box on the GoToWebinar control panel on your screen. Questions will be collected and answered as time allows. NCBA CLUSA will be recording this program and it will be archived onto our website. You will receive an email containing a link to the posted recording by early next week. Now, with that said, I'll turn the webinar over to our moderator, NCBA CLUSA President and CEO, Doug O'Brien. Doug.
Thank you, John, and thank you everyone for joining us on this Friday of the holiday weekend. Wishing everyone a good holiday weekend. Very glad to be able to bring a couple experts to you on this very important topic. I just have a couple opening comments. I first do want to recognize members of the cooperative family who are making it possible for everyone in the United States to have access to essential goods and services. This includes those folks in the food co-ops, at the agriculture co-ops, in the rural electric cooperatives, and in the financial institutions such as the National Co-op Bank, as well as the credit unions across the country and other cooperators. Thank you for everything that you're doing. I am Doug O'Brien. I'm the President and CEO of National Cooperative Business Association, CLUSA International. Among other things, we of course advocate for cooperatives. Our mission has been and continues to be to defend and promote and advocate for the cooperative business model. In the past weeks, that has meant a laser focus on making sure as many cooperatives as possible have access to disaster assistance being created in response to the COVID-19 economic crisis. We've seen a lot of activity in Congress. We've worked with Congress. We've worked with the administration, particularly Small Business Agency, and we've done this in concert with the cooperative community. Today, we're focused on the Paycheck Protection Program, and we look forward to hearing from Patrick Connealy with the National Co-op Bank. We also will hear from Ken Logsdon from the Dorsey law firm to provide their perspective from the lender perspective and the employee perspective. Before that, I want to hand over the camera and the microphone to Kate LaTour, the Director of Government Relations here at NCBA CLUSA. Kate has been the point person here at NCBA and working with the entire cooperative community on the different legislative initiatives. So, Kate, I'll hand this over to you. Thank you.
Thank you, Doug. Good morning, everyone. I am Kate LaTour, the Director of Government Relations, and thank you all so much for joining us this morning. As a brief background, and for those of you who may be looking at different programs that are available, I would just also refer you to our website, which has our webinar that we also held on the Economic Injury Disaster Loan and Grant Program. So for those of you that are also having some questions there, would refer you to that information set. So the Paycheck Protection Program was established in the third federal relief effort called the CARES Act. PPP, as it's known, is an expansion of SBA's existing 7A program. So many co-ops are eligible. That includes worker, food, agriculture, and purchasing. At this time, we are still waiting for a clear indication from the SBA and the Department of Treasury, but it does appear that other types of co-ops that are incorporated under the 501c umbrella may not be eligible for PPP at this time. As an expansion of 7A, PPP loans are made through private lending institutions, and these loans are 100% guaranteed by the Small Business Administration. Paycheck Protection Program loans are intended to be a much shorter loan than the EIDL loans, with terms being 2 years at a 1% interest rate. Under this program, loans can be forgiven if at least 75% of the funds were used to keep people on the payroll or rehire employees that had been laid off prior to the program's implementation when the initial impacts of COVID-19 were beginning to be felt. These loans are managed through private lenders and are calculated by determining 2.5 times the monthly payroll up to $10 million. And currently these funds are available through June 30th, 2020. The fund created by Congress was provided $349 billion under the CARES Act, and Congress is currently considering legislation that would increase that amount. It's important to note that for co-ops eligible for both the Economic Injury Disaster Loan and the Paycheck Protection Program loans, you may apply for both, but the funds may not be used for the same purposes. In addition, the Economic Injury Disaster loans can be refinanced as Paycheck Protection Program loans through the business's private lender that you're using. Businesses will have to certify with their lender how the loans are being used in order to receive that loan forgiveness under PPP. So I know that Patrick has a lot more information on this program. I will also, note that, like Doug said, we are continuing to work and with our allies on Capitol Hill to ensure that more co-ops are eligible for this program, and we'll be making sure that co-ops are eligible for any future effort as well, as we are expecting kind of an additional phase of legislation to be passed at some point in the near future in Congress as well. So with that, I will turn it back over to Doug, and then we'll look forward to helping out with questions and answers.
Okay, thanks so much. And again, on those questions and answers, please, folks, please just type those into the chat box that's provided. We'll get to question and answers at the end of the short presentations here. I'll be able to kind of being curated by Kate and others on my staff, and we'll be able to lift those up for our panelists. Next, I'm going to check on whether Patrick Connealy with the National Co-op Bank has been able to join us. We're working through a technical loop here. And Patrick, if you're on, please unmute yourself and say hello. And if not, Ken, I'm going to put you on deck and ask you to be prepared to share your insights. Okay,
Sure,
we're not hearing Patrick, right? Okay, and we're going to keep working on getting Patrick on the line here. But Ken Logston is a partner at the Dorsey law firm and has been working with many across the business community on PPP. So we're looking forward to your insight, Ken.
Yeah, you bet. Thank you. So when it comes to the PPP program, you just got a good overview of it. As an employer or a potential applicant / borrower, you're going to be paying attention to a few things that you need to in order to just qualify, right? That's the first thing you got to focus on. And what I mean about that is, you probably have heard that one of the standards is that you need to have no more than 500 employees in order to be, quote, a small business to fall into the program or within the parameters of the program. There are some exceptions, however. The one exception to that particular number is if you are in hospitality or food services businesses, you actually get a pass for having less than 500 employees per physical location. But otherwise, the 500 or less rule is across the board and something that you need to think about. Employers tend to ask, well, when do we do that number? If I'm sitting at 550 employees, can I furlough 60 of them and then qualify and then bring them back? Unfortunately, it's not that simple. The SBA has made it clear that for purposes of determining your employee count, it's the trailing 12-month, the TTM period that you average. You take the monthly average of employees and you average that out, and that becomes your employee count. Now, theoretically, if you actually were to furlough a good number of them, and let's say, I guess we'd have to say March, that might move your numbers down enough to bring the average below 500. I have had a couple of clients right on the line, and they have to do the math to just see if it works or not. So it might be worth doing if you're very close to 500. But that's how you determine the number. As for how do you determine employee, well, that's also something you must consider. The SBA has very broad parameters. The employee includes full-time, part-time, and the law goes on to say, or otherwise. Importantly, however, the SBA has given some direction to make it clear that independent contractors are not employees. It's really interesting because the act actually reads as if you can be an employer with independent contractor type arrangements that happen to be more or less those that are employees and not true independent contractors. There's still a little bit of a disagreement on how this is supposed to be handled. How I try to describe it is, look, I think any given employer knows whether they're dealing with an employee or an independent contractor, irrespective of their tax treatment, right? There are a non-insignificant number of businesses out there that actually do have employees full-time, and for all practical purposes, when it comes to their roles and their duties, they're full-time employees. However, for tax purposes, they use 1099. And so that's the area where it gets a little gray. Are these businesses doing it purely for the tax purposes? Mostly, yes. How does that affect the treatment under the PPP? That's a factual determination. One thing I've cautioned companies when doing this is to make it clear. Look, even though independent contractor and employee relationships are distinct, if you happen to be treating your employee base using 1099s for many years, and then for purposes of the PPP, you want to get the credit for them being bona fide employees, there is a risk on the back end that the IRS takes a look. The IRS probably has a list of companies they are suspicious of that use 1099s for tax purposes for their employees, and might want to take a look to see if you've also categorized them as employees for purposes of the PPP, because that's a standard that looks to the underlying facts. So that's something to be mindful of. If you're a bigger enterprise, another consideration is what's called the affiliate rules. Now, this can open up a big can of worms. The reason is, especially larger companies, they tend to have complicated structures. The SBA you must be mindful of is a program that isn't designed for big, complicated structures. In fact, this actually creates all sorts of problems. Congress, when they were tasked with rolling out the PPP, they could have done one or two things. They could have started with something completely new, whole cloth, and that would have been very difficult to do. We're seeing with what they're calling the mid-size loan or Main Street loan program, how that they're still rolling that out. The Treasury's still trying to come up with standards, but we're already seeing just a few standards that have been put out. It's becoming difficult already to see how it's going to work in practice. And Congress was aware of that limitation. So they decided to look to a program they already had called the loan program, the 7A loan program under the Small Business Administration, the SBA. They said, you know what, how do we take the PPP and just layer it on top of this? Well, it sounded good in theory. The problem is the SBA is traditionally designed to help small businesses get loans, usually independently owned and operated, usually businesses that don't have subsidiaries, very simple structures by design. It also is the program that's used to create guidelines around the types of companies that can contract for or bid for lucrative government contracts. And because of that, you literally have decades of new laws and rules and decisions that have created what we call the SBA rules and regulations today. And they have made sure that all sorts of holes in the rules and regulations from the outset have been plugged along the way. And that includes issues around companies that look to take advantage of government contracts when they might not otherwise should have been able to do so. And that is really the impetus behind the affiliate rule. It really is about getting behind the company to see who controls it, who manages it. And if there is an entity out there that controls and manages a particular company, should that entity be treated as just being the company? And they need to also satisfy the requirements for purposes of receiving a loan or getting a government contract. Well, that hasn't changed. There are a few exceptions. The law, the CARES Act, does make clear that hospitality and food services and franchise businesses and any companies receiving financing from an SBIC, that's the world in which you do not need to, quote, run the affiliate test as it's being described as. For all other businesses, you do need to look at affiliates. You need to look at the entities and the people that control the organization that's looking to take advantage of the program. If you have a company that happens to be wholly owned, you got to pick up that parent company. That becomes part of the company. Now you got to look at the employee base there to see how many employees there are. As you can see, it doesn't take too far up the chain before things get incredibly complicated. And that's been the big concern in the private equity, in the venture capital community, is they have funds that are set up to own independent, they call them portfolio companies, but independent operating companies doing all sorts of different things. But the minute you run the control test, you find that these funds essentially are one giant aggregate company, and they have to pick up the employee base for all of these unrelated businesses, and they quickly run afoul of the 500 employee or less rule, and the program doesn't fit. So there's been a great deal of focus on that. So if you have a company that's relatively large but comfortably under the 500 employee number, be mindful. You got to pick up all types of employment, full, part-time, or otherwise. Be mindful of independent contractor treatment and how that affects things. And then also be considerate when looking at the structure to see what entities happen to manage or control the applicant, because you will need to factor in those elements as well. In the question and answer portion of this, we can get into the details on how you calculate the loan and the forgiveness and so forth. But I think for a general overview of things to be very mindful of right out of the gate before you decide to take the leap and submit an application, those are the items that I would focus on.
Ken, that's great. Thank you for that insight. Invaluable, really. And we do look forward to that question and answer period, which after the short presentations here, we will be having those. If you do have a question, again, just use the chat box in the go-to webinar box to your right. I understand that Patrick Connealy has now joined us. Patrick, are you with us? Can you hear us?
Can you hear me?
Yes, we got you, Patrick, and very glad to have you along. Patrick is Executive Vice President at the National Cooperative Bank. Patrick also serves on the board for the National Cooperative Business Association. So very glad to have you on to share your perspective from the lender side of things. So Patrick, take it away.
Well, thank you, Doug, and good morning, everyone. I apologize for the technical issues. NCBA has issued some new laptops lately, so we've got some very current, updated, sophisticated, and highly restrictive laptops. So a number of sites just simply will not launch. Fortunately, being sheltered in place, I have my lovely spouse's beautiful monitor in front of me, and it works well. So anyway, good morning. Yeah, so the interesting thing about the PPP program, as Kate referred to it, is that this program was just launched a week ago. So, I mean, in real terms, it's still very, very much in its infancy. And I'm sure a lot of you have heard all of the griping and frustration from the past week. We at National Cooperative Bank have encountered some of that. I think we currently, just to give you an update, we currently have about 120 applications for a little over $50 million. And we're just a small player. It's a very, very interesting, it's not a complex program. From a banking perspective, it's an easy lift. It's just that the guidance from the get-go has been kind of a work in progress. I mean, every day we get some updates from SBA in terms of how we should approach certain nuances. So that's kind of the nature of this program. Last week, NCBA hosted a webinar on the economic injury disaster, something like EIDL, I call it EIDL. And the difference between that program and this program is that the economic injury program is a direct loan from SBA, and the application goes directly to SBA. So lenders aren't involved except to the extent that that program works for a customer as opposed to the PPP because of eligibility, for instance. Then our opportunity is to direct our customer to that program. But as I alluded to, the PPP program is relatively straightforward, and I don't know if you have the PowerPoint slides that I provided. Maybe we could switch to the first one. Okay, there we go. I'm not going to go through each one of these in any level of detail. I think, Kate referred to some of the program parameters. Ken talked about some of the program parameters from a legal and affiliation standpoint. And the affiliation rules with SBA are something that you really have to pay attention to. So I appreciate him, raising those points because believe me, that's one of the more complex pieces of this process. Anyway, the first one, as you can see here, is am I eligible? And you've heard other people talk about this. For the Paycheck Protection Program, it's for small business companies with 500 employees or less. From a cooperative perspective, and I think both Doug and Kate alluded to this, but from a cooperative perspective, it really captures the small business cooperatives in the purchasing, consumer, agricultural, and worker cooperative arenas. Rural electric cooperatives or 501c12s, they are not eligible for this program. The only not-for-profits eligible are the classic 501c3s and the veterans organizations, which are 501c19s. I know that there's a move afoot, at least when the second phase come out, to put some language in the legislation that would broaden that. But for the first phase, it's just the 501c3s and the 501c19s. So there you can see, and for your information, the bullet points, you talk about the eligible organizations. And then I think, as Ken alluded to, there are some special rules that apply for organizations that are over 500. And those are predominantly, franchise type organizations and others. So that's the eligibility piece. If we could go to the next slide, I'll talk a little bit about what lenders are looking for. So the greatest thing in the world that a lender can have is a program where all of the certifications, all of the requirements to, basically certify that all of this information is correct is on the borrower. So I think SBA in its infinite wisdom knew that if they wanted to get this program working up and what have you, that they needed to make it as inconsequential as possible for the lender. Not that there isn't fiduciary responsibility there is, but by and large, most of the protections are such that it's the borrower's responsibility to certify many, many things. So from a lender's perspective, we're looking, this is what we're confirming, if you will. So we're going to ask for that certification about the current economic conditions. And the uncertainty of current economic conditions is kind of a broad, it's a broad statement. In many cases, or in some cases, the applicants that we have can demonstrate right now that the economic conditions make this loan request necessary. But in a lot of cases, it's more that they at the current time, it's not necessarily horrible, but because of the uncertainty of what's going to happen, that's why they're making the loan request. And as many, I think Kate mentioned this, the proceeds have to be used to retain workers, maintain payroll, and can be used, a portion of which can be used for mortgage payments, lease payments, utility payments. I think that's, I'll go on to the next one. We don't have to, a couple of things that the lender doesn't have to do. There's no requirement for personal guarantees. There's no requirement for collateral, and you don't have to demonstrate that you can get credit elsewhere. Those are all standard SBA SOP requirements. So a lot of those have been either relaxed or waived. Okay, we can go on to the next slide. So how much can I borrow? And I know Kate talked about this, and this is one of the things, this is probably where the bank spends most of its time, is just confirming that the calculation is correct, that it's been done properly, and that we have sufficient documentation to back up that calculation. So if you're gonna send us an Excel spreadsheet with names and dollar amounts of wages, that's not going to work. We're going to need to have most likely W-2s for each employee to back up that spreadsheet. Or if you're a payroll company, then a lot of the payroll companies provide detailed information. We can get the Form 941. So there's different ways that we can document it, but by and large, that's probably the highest priority we have, is making sure that the calculation for this program is done properly. And included in the payroll cost, really it's gross wages on behalf of each individual employee, and it's capped. The actual cash compensation is capped at $100,000. So, when we review the calculations, we make sure that they do cap the cash compensation at $100,000 if that's necessary. But you can add the benefits, the healthcare costs and the benefit costs over and above that. State and local taxes over and above that can be added. So it's not a $100,000 cap. It's $100,000 cash compensation plus, the extras. The one thing that is excluded, the most important thing from an exclusionary perspective, is payroll taxes. So your federal income tax is not included in this calculation. And the final slide talks about, that's the excluded costs. So payroll taxes and railroad retirement taxes. That one was we haven't seen any application where that's come into play, but it's good to know. Next one. Okay, and this is kind of the icing on the cake for this program. There's the ability to have these loans forgiven, and that was really the whole point of the Paycheck Protection Program, was short-term liquidity, really for the purpose of keeping people on the payroll. So how much? The borrower is eligible for loan forgiveness equal to the amount for the 8-week period, which begins on the date the loan is actually closed and funded. So 8 weeks from the date the loan is closed and funded, the borrower can make application to have the loan forgiven. And the payroll cost, these are the items that can be forgiven, as long as they can be properly documented. And the reason it's 2.5 times, it's an 8-week period. So basically the 8-week period covers payroll, and then the extra 0.5% is really to cover those extra costs associated with interest on mortgage obligations, rent, utilities, etc. So that's why it became 2.5 times. But the point is that by and large, if you come to that end of that 8-week period and make application to forgive, I would venture to say, based on the way this is working, that a very, very high percentage of your loan is going to be forgiven. There may be circumstances where there's a small residual, but by and large, I think the idea is that the vast majority will be forgiven. You can see down at the bottom there, how could the forgiveness be reduced? And this is certainly possible. It's reduced if there's a reduction in the number of employees, or a reduction of greater than 25% in wages paid to employees. So that's just one of, there's other ways that it could be reduced, but that's probably the most likely. So Doug, Kate, and John, others, that is the gist of my presentation. Be happy to answer any questions.
Well, thank you, Patrick. Great set of slides here that we will also have posted on our COVID-19 microsite that's easily found on the NCBA CLUSA homepage. Yeah, we do have time for questions, and there's a bunch of them that have come in that we're curating. So I have those, and I'll just kind of start asking some of them from the spreadsheet that staff's presenting to me, and then kind of field it, and folks can volunteer here from the panel. If folks have other questions, please, if the audience has other questions, please do just type those into the box, and we'll try to get them answered today, and if not, we'll get them answered in the near future. So the first question I have is that the EIDL, that Economic Injury Disaster Loan Program, also part of the COVID, those funds are less restrictive about what you can use them for. If you receive a $10,000 essentially grant from the disaster loan program, that's part of the feature of EIDL, does a business, in this case, does a cooperative, have to count it into the co-op, Paycheck Protection Program loan app? And if so, does the use of that $10,000 become restricted to the PPP uses and the 75% ratio, or 75 to 25% ratio on payroll versus non-payroll? So a fairly complicated question, but I think I might just back up and ask Patrick or Ken to talk about that interaction between EIDL and PPP. I think that's a question a lot of our audience would have today. And Ken, maybe I'll ask you first, and then Patrick.
Sure.
We can hear you. Go ahead, Ken.
Can you hear me okay?
Yep, please go ahead.
Okay, sorry. Pat, you can correct me if I'm wrong, but on the 10,000 component EIDL loan, there was a final rule put out by the SBA that actually broke down and actually contained examples of how that factors into the loan that you're going to get under the PPP. And what it actually ends up adding to the loan amount under the PPP. It's unclear how that affects the use of proceeds. It does affect the loan amount itself, but I mean, theoretically, that $10,000, I think it's under the Express program. It's supposed to come out pretty quickly. I think you can get as quickly as three business days, if I'm not mistaken. And that would be in a situation where you haven't even applied to the PPP, right? But you were using those funds for business purposes in accordance, of course, with the EIDL. So I'm not so sure there's the intent to restrict the use of proceeds there. It's very likely those amounts may have been spent by the time you actually apply and get approved under the PPP. But I don't know, Pat, do you have any thoughts there?
I know exactly what you're talking about, Ken, in terms of adding it. And so, one of the things we discussed is, well, why would they add that? Why wouldn't they subtract it from the PPP? But I think our conclusion, which is our conclusion, it belongs to absolutely no one else, is that because the $10,000 is essentially a grant, and because the PPP program is subject to forgiveness, that it just essentially raises the amount of forgiveness, and that's kind of how we arrived at it. But I think you're also right, Ken, that it's probably inconsequential how the proceeds are used, because by and large, most of them have probably been have been used prior to any PPP application.
Yeah, you make a good point, Pat, on the grant component, because what's interesting is, there's an echo, I apologize if that's, maybe there we go. Oh, no, still there. Someone needs to mute their phone. Okay, thank you. What's interesting, Pat, you make a great point. The rules have not discussed how does the EIDL 10,000 amount factor into the forgiveness, right? That's really interesting. They talk about how it factors into the front end loan amount, but not on the forgiveness side. But just bear in mind, when you're looking to get the loan forgiven, it's a very short and specific list. It looks a lot like the use of proceeds list. It's not exact. That's something else to be mindful of. But essentially, it's a short list, the similar list to that of the use of proceeds under the PPP. So why does that matter? Well, the 10,000 is the loan amount, right? It's the loan amount plus that $10,000. But if you're looking for forgiveness, you're still only going to get the credit for the expenses in that 8-week period. So you could easily have a situation where you didn't, quote, get the full forgiveness of the 10,000 because the loan amount happened to be much larger, than the expenses you're going to get credit for purposes of forgiveness. So I think you do need to look at those differently and just realize the forgiveness is being driven by a completely different analysis.
Okay, thank you. Thanks for that, Ken and Pat. I know that there were a number of questions on that interaction between PPP and EIDL, so I'm glad we had a chance to kind of go a little bit deeper into that. The next question, these are, I think, a little bit more straightforward. First, and this might be for Patrick or Kate, at present, are housing cooperatives eligible for the PPP?
Well, again, this is Patrick, but again, one of the things we delved into deeply, and our general counsel delved into deeply, and the SBA regulations speak to passive organizations not being eligible for SBA loans. And our general counsel has concluded that the housing co-ops would fit into the definition of a passive organization. So at this point, unless the legislation, we've even looked at the second phase language that's being proposed, which would include a number of cooperatives that are organized under various not-for-profit designations of 50, the C12 being the rural electrics, for instance. And we've concluded that unless that language specifically says housing cooperatives, that it will not suffice to include them in the second phase either.
Okay. All right. Pat, thank you for that, Patrick. And I'll just say, just from NCBA CLUSA's point of view, that in that, that what might be known as CARES 2, that Congress is considering right now, NCBA is working with housing co-ops and across the co-op sector to work to try and make sure as many co-ops are as eligible as possible. So we appreciate that comment. Ken, maybe I saw you raise your hand there.
No, I didn't, but
okay.
I did have an interesting thought there. We had a client, we took a closer look at this, and we weren't focused on co-ops, we were focused on homeowners associations. And that's an interesting question. It doesn't seem to be clear that the PPP covers those types of entities. The traditional EIDL program does. And so there are some interesting gaps, and it's not clear they were intentional. But I think the housing co-ops are a really good question.
Yeah. So the next question I have here is, most of our worker co-op clients are small, formed as limited liability companies that have not yet checked the box to operate as corporations under subchapter T. Many of them do not treat their worker owners as employees. How does this work under PPP?
Well, Pat, you probably want me to take that
question.
So the question is, it's an LLC, and they do have employees. I'm a little confused by the question.
So it's a worker co-op that is, has established itself under state law as a limited liability company. That's how it's filed with their Secretary of State. They are wondering. Well, number one, I'll just mention, and maybe Ken, you'd mention this too, that LLCs are eligible for PPP. So that's very clear. And worker co-ops are eligible for PPP. So that's really clear. I think the question is, and a worker co-op, many of them, they don't treat the workers as co-ops because they're worker owners. So, are those worker owners who actually do the work for the firm, in this case, a co-op, how are they treated for PPP?
Oh, that's a really good question. Because I've gotten this question in different forms, such as LLCs where their members just take a distribution instead of compensation. Partnerships, right? Partnerships have an interesting question. For tax purposes, they much look like independent contractors and so forth. I guess if they're being compensated as an employee, if you can show in reasonable detail that they are in fact being compensated as an employee, then I think that's what you'd have to produce to have that good faith evidence that that's in fact what they are. If the compensation is some other form, right, some kind of the production of the co-op overall, that gets a little more unclear, because then it looks like comp based on equity and it's more the form of a distribution or dividend. And then you kind of start moving towards the independent contractor / sole proprietor world. I mean, are those individuals essentially, are they independent contractors or sole proprietors or self-employed that happen to be in a co-op? So I think that's a really factual specific question.
Okay. All right. Thank you. Thank you. It is a really good question. Some of my staff and I were pondering that the other day. The next question we have, this I think was somewhat addressed, but it's a really important question. It's come up a couple times in here. Does the applicant need to have evidence of economic harm to the co-op? And if so, what is the lender and ultimately SBA looking for? The concern is that the co-op may have trouble if expenses keep being high and sales keep dropping, in the future. So, Patrick, I think you touched on that, but maybe Patrick and Ken, you talk about that just a little bit more.
Well, again, I think the statement for the certification is fairly broad in that it talks about economic uncertainty. And as I mentioned, we have applicants that have experienced economic duress when they've made application. And we have applicants that are making application because they're just not sure what's going to happen. So we've had this question posed to us a few times, and we certainly feel, particularly for those cases where it's perspective uncertainty, that you think it through, and that you have some sort of statement that you can make in the event that somebody audits you when you make application for forgiveness. But again, I think it's completely subjective.
Okay.
Yeah,
Thank you,
I would add to that, Pat.
Go ahead, Ken.
Pat has the lender hat on, which thankfully for lenders in this particular program, they don't have to do a lot of heavy lifting, really, at the end of the day. And that's by design, and I think that's smart. So this program is done effectively and efficiently. And so the onus is on the borrower for many things: general compliance with the program, et cetera. And of course, that includes this particular issue. The application itself says, and this is quote, "Current economic uncertainty makes this loan request necessary to support the ongoing operation of the applicant." Some strong words in there, necessary. I mean, you taking that, read plainly, that seems to be a high bar. But what's interesting about this is that the traditional EIDL program, it actually has a bar of substantially impacted, and it's understood that that's certainly a higher bar than what they're getting at here. And Congress purposely removed substantially impacted from the analysis because they thought that would be too high of a bar. What I have been kind of directing my clients on this is to say, look, if you have a good faith analysis that these funds are needed, especially needed for payroll costs, and clearly in cases where otherwise you're going to be furloughing or reducing salaries, that's clear, right? But I do think it makes sense. I think it's prudent to take a closer look at your financials to make sure that you can say, yeah, this is needed for ongoing expenses due to the impact of COVID-19. Many companies don't have trouble satisfying that, right? But the one thing to be careful about there is that there are some groups out there that aren't terribly happy with this stimulus. And they've already said they're going to make sure that they use the Freedom of Information Act to comb through records and to find those who might have been a little too fast and loose on their certifications. And so there is the potential of false claims acts and running afoul of federal law. So I wouldn't take the question lightly. I think you do need to make a good faith determination with some consideration at looking at the financials. And if you can support it with documentation, even better. But do that before you sign the application, and be cognizant of what you're saying when you make that statement.
Right. Thank you. Thanks, Ken and Pat, for those comments. We're at about 5 minutes left, and we got 2 or 3 I think that we really want to hit, and so we might want to do them in fairly quick fashion. This is one I know a lot of cooperatives have been asking: is how should a consumer co-op with hundreds of owners complete the applicant ownership question, one of the first questions in the form? Obviously, no one owns 20% or more, and so Patrick, I might ask you, and Kate may have some insight on this too. I'm not sure, and Ken certainly. So, how does a co-op fill out that applicant ownership question?
Well, it's a good point, because the application obviously doesn't conform well to consumer cooperatives or cooperatives of any sort. But what we suggest is that who's ever filling out the application, put themselves in as the owner, if you will. At least on the application, there's an addendum. When the addendum is completed, I think they can put the clarification in the addendum in terms of, we're a cooperative, we have no single owner, and here's a list of everyone in the cooperative. Interestingly enough, when you upload the application to SBA through ETRAN, there's also there's an area where that has to be completed, and we do the same thing, which is you put in, whoever fills out the application, that name goes into the owner category, and then there's actually a box for an explanation, and then the explanation box is where we explain, the structure of the cooperative.
Okay. All right. Thanks. And Kate, I'm trying to remember. I've seen so much literature on PPP in the last few days, and co-ops that actually Kate's been sharing with me more than anybody. I seem to remember. Is there something that you can add here?
So we are continuing to work to try to make the application more co-op friendly, so that it's really easy for lenders to understand, yes, co-ops are eligible. Here's how they would fill that out when they don't necessarily meet that 20% ownership threshold. At this time, though, that form does not exist. And so I think Patrick's advice is right on track of how, if you're facing that issue with your lender, you can explain that kind of process and how other lenders are processing.
Okay, very good.
There's an alternative approach. Yeah, there is an alternative approach that we've found success among our clients, and that is put in the co-op name instead of the owner filling out the application. And that has seemed to be sufficient for purposes of processing, both on the front and back end. So a couple ways to do it, but there are some interesting questions as to putting the applicant, the individual, down as, quote, the owner. Are they really the owner, right? I mean, that starts getting kind of far afield in some legal theory. But if you're not comfortable doing that, you can also just put the co-op name, and we have found that is working.
Very good. Okay, thank you, Ken. So last one. Does the co-op need to apply for forgiveness, or is it on the lender to calculate, or how is that forgiveness determined?
That one's for Pat.
Well,
Pat.
Let's put it this way. This program's 1 week old, and my guess is that at this point, theoretically, it is up to the borrower to make application for forgiveness. What that looks like and what the conditions of forgiveness, I think those are a work in progress, because that's 2 months away, generally speaking. And they're so focused, SBA is so focused on the front end at this point that they really haven't designed the back end yet. But one thing that will be certain is that it would be up to the borrower to apply for forgiveness.
Right. Yeah. Okay. Okay. Good. Thanks, Patrick. We have time for one quick one here, and there may not be a good answer, but smart people on the panel here might have a comment. What's the time lag that should be expected to receive a response on an application?
We have again, and our with the workflow we have, we get an application, we do our confirmation, we do an internal approval, and we upload it to SBA, and we try to get all of that done within 3 business days. At the present time, and this gets to a question you didn't ask, but I'll address it, on the closing side. Again, there's nuances from a closing perspective that have not been addressed by SBA. So, while you see all the statistics out there about the hundreds of thousands of applications that have been approved by SBA totaling 150 billion or whatever, I would submit that there's probably a very small percentage of that have actually been closed and funded. While we wait for proper authorization and guidance to move forward. I think that's imminent, but once it's uploaded and approved by SBA, the closing process will not take long because it's very, very light documentation. So it's just a matter of getting to the front of the queue and getting your loan closed and funded. But I think if things were working well, I would say that within 1 business week or 5 business days, you could go from application to funding.
Okay. Okay. Thanks. And we certainly heard in press reports that that there has been some delay. There's just been such a crush of applications. So I know as Ken mentioned at top that SBA is doing their level best with a program that their tools aren't necessarily fully equipped to deal with. So that's good advice. So we are at time here. Just a couple things. First, thank you to Patrick, to Ken, Kate for being on and sharing this really critical information to the cooperative community. As Kate and I have mentioned, NCBA CLUSA and our advocacy work will continue to work with the entire cooperative community to make sure that legislation makes clear that as many cooperatives as possible are eligible, and also that the SBA application and other applications are accessible and really make sense for co-ops, and we're continuing to do that work. I want to say thank you to the members of the NCBA CLUSA. We are a membership association. The work that we do on advocacy, this type of webinar, is possible only because of those membership resources. So thank you to those listening who are members of NCBA CLUSA. To those who aren't, please check out our membership page and consider joining your cooperative community and supporting this type of really critical work. I hope everybody is safe and healthy. Please take a look at our COVID-19 resource page. We continue to grow that and build the resources. This webinar will be posted along with the other webinars early next week. And there's some other great information on there. Everybody take care. Have a good holiday weekend, and we'll see you soon.
Thank you.
Thank you, Doug.